Hi, this is Attorney Mike Gravel coming to you from Chicago as usual, and today's a big day. Sometime in the overnight, we crossed over 25,000 subscribers, and I want to thank everybody. That is awesome. I never thought it would get here. I know everybody says that, but it's true. I never thought it would get here, and it's been so much fun. And I got a good clip from 3B today. That's what I wanted to do. And in addition to that, I got a fun little thing. It was sent to me by a viewer. I could have nothing better than this, honestly, to celebrate the 25,000 subscribers. And that is the prosecutor in the 36th District Court today decided to mention to Judge Bryant her playlist. It's fantastic. And then her response is even better. She just has a big, bright smile, lights up the room. You guys can tell me in the comments below when you see that. I'm gauging by the smiles, people that I suspect are viewers of Law Talk with Mike. If you're getting the joke, I think you've seen Law Talk with Mike. That's my theory on this topic. But let's first go over to the 36th District Court. And, you're not in the 25th District Court. You're not in the 10th District Court. You're the one and only place you are is the 36th District Court. Let's go check it out.
And Mr. Kelly isn't here yet either. I'll put you back in the waiting room and see if they come. If they're not here about 10 o'clock, I'll release you.
Okay, sounds good. I'll keep going and watching your greatest hits playlist on YouTube.
See, don't do it. Don't do it. So you looked it up, Mr. Wakula?
Yeah, I found it pretty quickly.
Yeah, let me put you back in the waiting room.
See right there, Jessica Schaub. I'm sorry, I'm yelling into the mic there probably. Jessica Schaub is smiling. I think even Janice Stevenson knows what's going on. I don't see any sign of recognition from our prosecutor, Christina Ritter, but that's okay.
Mr. Wakula, those defendants have not appeared, so I am going to release and discharge you from your obligations today, unless we call you back.
Yeah, no problem. If they show up, you can just shoot me an email. I'll be around.
All right, and clear your mind and get off that channel.
Yeah, right. You're right. I'm not going back. Don't worry. No more views.
All right, we're doing okay. We've got Mr. Grant here at the courtroom, and we've got Mr. Kevin Klein here with his lawyer, Mr. Peter Taylor.
All right, it's been a little while since we've been over to 3B. This one was fun. A bunch of people sent it to me, and I understand why. It's fun. We all know Prosecutor Deborah Davis, and she's awesome. She's been on. We're friends and all that good business, but she is not happy here, and it's funny. She has good reason to be upset with this deal, and she is.
Pull that case up. This is file 212085SD, People versus Kevin B. Klein. Mr. Peter Taylor is here by Zoom connection. He's right. I don't know why, but this was set for Zoom appearance rather than live. He is here. His client, Kevin B. Klein, is here as well. Mr. Klein is charged with operating while intoxicated.
Thank you, KF Welsh. And I know Natalie and Artie would say the same thing.
As a first offense, subject to being charged as a fourth offender, but he was charged only as a first offense. And the prosecutor's office and Mr. Taylor have worked out a plea, as I understand it, to impaired driving. So Mr. Taylor contacted the court a number of weeks ago and asked us to set up what's called plea, screen, and sentence, where we do everything all at once. So you've already done the screening with Matt Huff, and you've also done the victim.
Thank you, Pamela. Yeah, she's awesome. And, you heard the setup. They offer the guy a plea deal thinking it's his first offense and it's his fourth.
Impact panel somewhere where you live. So the matter is set for a plea. So let's talk about that. You're charged with operating while intoxicated as a first offense. That's a misdemeanor, punishable by up to 93 days in jail and a fine of up to $500. Carries 6 points on your driving record, and it requires that your license be suspended. And you also would have been subject to charging with either second offense or third offense, but they did not. In addition to that, the prosecutors agreed to dismiss the charge of driving suspended for a plea to impaired driving. Impaired driving is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $300 plus.
I found it pretty quick.
Oh, I lost it. I moved this. Sorry. Oh no. Well, thank you, Judy. I appreciate it. He was going for impaired driving. I'll get us back there.
Charged as a fourth offender, but he was charged only as a first offense. And the prosecutor's office and Mr. Taylor have worked out a plea, as I understand it, to impaired driving. So Mr. Taylor contacted the court a number of weeks ago and asked us to set up what's called plea, screen, and sentence, where we do everything all at once. So you've already done the screening with Matt Huff, and you've also done the victim impact panel somewhere where you live. So the matter is set for a plea. So let's talk about that. You're charged with operating while intoxicated as a first offense. That's a misdemeanor, punishable by up to 93 days in jail and a fine of up to $500. Carries 6 points on your driving record, and it requires that your license be suspended. And you also would have been subject to charging with either second offense or third offense, but they did not. In addition to that, the prosecutors agreed to dismiss the charge of driving suspended.
Thank you, all dog. 25K, well deserved. And here's to many more. That is so sweet. And as far as this plea goes, it is a sweet deal, but I think it's probably a standard first-time offender deal. That's the vibe I get out of it.
For a plea to impaired driving. Impaired driving is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $300 plus costs rather than $400. Carries 4 points on your driving record, and it would allow you to keep a restricted driver's license. Although with more than one case, I don't think you're going to be eligible. You're also an Indiana driver, so I don't know what the status will be for your Indiana driving privileges.
Thank you, Vincent. Just send me the picture. IG is probably the easiest.
Mr. Taylor, is that your understanding of the plea agreement?
Yes, Your Honor.
Ms. Davis, you agree?
Your Honor, my notes indicate that that offer was made with the understanding that Mr. Klein didn't have any priors. So I know this was negotiated with APA Johnson and Mr. Taylor, but
So, Deborah, is that a no?
nothing indicates that our office was aware that he had 3 other priors and was on probation for 1. The only CCH we have is a Michigan one, and it does not have OWIs on it.
Well, so what's your position? Are you going to stand by the offer or ask to?
I don't think it's an appropriate offer based on the information that we now have, that it's in fact his 4th OWI. And I need to see if Mr. Johnson was aware of that when he made this offer.
All right. Well, Mr. Taylor, what's your thought on this?
My thought is that was the offer. I mean, I don't have any charging discretion. That's the prosecutor's office who has charging discretion. They're the ones, I mean, the state of Michigan is the keeper of the criminal history. They're the keeper of the driving records. The prosecutor certainly has more access to information than I do, or certainly Mr. Klein.
I don't know. This brings up an issue that nobody seems to care about, and I literally don't do it, so I don't care. But The judge later says, I think you knew about it. I think the attorney did know about it. Does he have a duty to disclose that to the prosecutor when he's cutting a deal? I would think he does, but this is his argument is fine as far as the judge goes, but is not convincing Deborah of anything.
Mr. Huff had no difficulty finding this stuff when he created the pre-sentence investigation report. And Mr. Klein's acting in good faith here. We have an agreement to plead to an impaired first, and I believe the prosecutor's office should be held to that at this point, and especially since we have a different prosecutor, expressing an idea of wanting to back out of the agreement.
Well,
Oh yeah.
I will say we do have part of the Indiana CCH, but there's nothing mentioned about any OWIs.
all right. Well, it's in essence a specific performance type of argument by Mr. Taylor, which is persuasive. Mr. Huff put a lot of time and effort into this case. He and I discussed it on Friday and then discussed it again this morning.
I mean, that's interesting. The judge goes to a specific performance type argument and later says there's a body of case law, which does make some sense, but you're applying contract principles to the scenario. Basically, we've now entered into a contract, offer and acceptance. You've offered this as a plea deal and we've accepted it. And now we want the benefit of our bargain. It's straight contract law. And that happens a lot. You sort of use those principles by analogy in another area. There's nothing wrong with it. In fact, prior decisions may have used that very logic and now made it law through common law.
Trying to figure out what to do here. So I don't want to go through with a plea because jeopardy could attach if he is charged with, not jeopardy, but the factual basis if the prosecutor amends it. So at this point,
That is interesting right there. I would really like to have Keith or Derek or one of my defense attorneys on. It's interesting what the judge is saying. He doesn't want the factual basis to attach to it. And I get this. If they do a factual basis in court right now, that's part of the record. And then the prosecutor amends it and says, no, we're doing this as a felony fourth DUI. Now he's stuck with a factual basis when he was like, I gave that for the thing that I bargained for. But if I would have known we were going felony, I wouldn't have given that. So it's an interesting position.
Have to be a dismissal at this point if the prosecutor's not willing to go through with it, Your Honor.
I think you're right. Well, another option is to motion to withdraw a plea agreement, but they'd have to either just proceed on this or recharge it as a felony. Mr. Johnson isn't here. I think it was probably made in good faith. Although I think you knew he had priors. If you didn't, you weren't doing your job. You're right, you don't have charging discretion, but you do a thorough job vetting your clients. So you may have sold him a pig in a poke. He didn't know that there were priors, and I would greatly suspect that you did.
See right there, and Judge knows darn well. He knows the attorney, and he knows he ran his abstract, and he knows the situation, and he didn't mention it. This is why Deborah's upset. Yeah, he probably doesn't have a duty to disclose it, but you can have that conversation with the prosecutor when you're doing this. Those conversations are usually private, on a phone in a conference room, something like that. And she's just not happy that they weren't aware of this, and it does make a big difference in this case. Thank you, McLean. I appreciate it.
Certainly the defendant knows there were, but I'm gonna adjourn this to allow the prosecutor either to move to withdraw the plea agreement or dismiss it. Now, if they move to withdraw the plea agreement, that isn't a foregone conclusion that I'm gonna grant it. I may grant Mr. Taylor's specific performance motion. As he indicated, Mr. Huff didn't have any problem finding any of this stuff.
Thank you, Chairman.
And if the prosecutor didn't through neglect or otherwise, he may still be bound by the plea offer. But let's adjourn this
Thank you, Fulgent.
to allow 21 days.
I am going to be out of town on vacation the 15th to the 25th of February.
Me too. So that's where I'll set it. Neither you or me will be here, and we'll let somebody else take.
Your Honor, I would request that this one be in person with the defendant in the courtroom.
Ooh, Deborah does not like this. She wants that defendant showing up live. She is not happy. Again, I wouldn't be either. This guy's a danger to society, and they gave him the deal probably that's typical for a first time offender.
Yes. All right.
Is this going to be reset for a motion hearing then, or for a plea and
Well, I'm going to
sentencing?
allow 21 days for the plaintiff, for the prosecutor to file a motion to withdraw a plea agreement. Or dismiss. But even the dismissal motion, Mr. Taylor still got a specific performance type of argument. And there is a body of law on specific performance of plea offers that I'd have to take a look at. So that puts us into March. Mr. Taylor will have another vacation in March and another one in April.
Thank you, Gia.
Maybe June. A guy we all know practiced in Marcellus for many years would take a week's vacation every year in the winter months. He would take a week in January, a week in February, a week in March, and a week in April. But he got to the point in his career where he could do that.
Be nice.
Thank you, Alan. And agreed. Yes. Look
That's
at that
your dad's
expression right
job.
now.
You guys keep the ship running, and then
That is his job now.
have you guys run the ship, and he takes the vacation time. How about March 7th? At 10:30.
Oh, thank you, Leanne. I appreciate it. So you're going to listen to this after that. I appreciate it.
And that will be in person, correct?
Yes. Or live motion hearing or sentence. Mr. Klein, Mr. Huff has been in communication with your probation agent in Indiana, and they're kind of waiting to see what we do before they decide how to proceed on what they do. And Debbie, as you can see, Matt's done an excellent pre-sentence report. Maybe you and Casey could consider that, discuss it with Matt. But Mr. Klein, at this point, there's some uncertainty as whether the plea offer is outstanding. And if it isn't outstanding, whether the prosecutor has authority to revoke it.
I don't think that plea offer is going to be outstanding after Deborah speaks with Casey. He's going to say, I thought it was a first-time offense. I'm guessing. I don't know. I don't have any inside information, but I think that's how that conversation is going to go down.
So we're going to continue this to be live and in person here in the courthouse in Centerville on March 7th, 2022. All right, Mr. Taylor, have a nice vacation. Are you going someplace warm?
Your Honor.
All right. We will try again. All right, Mr. Klein, good to go.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Well, thank you all again. I really appreciate it. I can't believe Law Talk with Mike has come this far with its humble beginnings and funky corpus delicti. But that was a good clip I was just going to do. And honestly, I was surprised. I didn't know we'd crossed 25 that fast. I woke up this morning and saw that, and I thought, well, I'll just mention it in the video that I was already going to do. Oh, but we also had the extra fun from the 36th district, and that was really fun. Thank you for sending that to me.